body, be it public or private, to initiate or promote, constitutional amendment through popular initiative, provided procedure laid down under Article 257 has been adhered to. The only requirement under Article 257 that a promoter has to fulfill first is for you to convince others, get 1 million signatures. On the other issue of the sufficiency of the regulatory framework, it is our position, and we submit that the Superior Court erred in finding that there was no legislation or legal framework to govern the collection, presentation, and verification of signatures or conduct of the referendum. We submit that the Constitution of Kenya, that the Election Act provides sufficient guidelines, be it for IEBC or Parliament, to carry out their processes in popular initiative, amending the Constitution through popular initiative. And we rely on the position of the court in Titus Alila that you've been referred to severally, where the court found that the Constitution already had a set up mechanisms or legislative framework for holding a referendum.
Thank you, Mr. Omulwa.
My Lord, the last comment, just on the JLAC report, just to comment.
Yes.
My Lord, I want to direct this court to the affidavit of Mr. Miru Waweru, in which they produced the Hansard of the Senate of 28th April and 29th April. My Lord, that Hansard, they selectively chose the 2 days. They did not provide the Hansard of the 13th May, when the Senate actually also deliberated during third reading.
13th May.
13th of May. And actually, overwhelmingly passed the constitutional amendment.
Have you provided it?
We have in our affidavit, my Lord.
Okay, thank you very much. We will look at it. Your time is up. Thank you very much.
Thank you, my Lord. And I wish to state that you allow the appeals as prayed by the appellants. Thank you.
Thank you, Counsel. Who is next? Mr. Ndegwa. Are you here? Mrs. Ndegwa. Is there anyone representing the 43rd respondent? The indication we've gotten is that 43rd respondent was also supporting the appeal.
May it please the court?
Yes, Counsel, introduce yourself.
Mboshe is my name.
Sorry?
Njoki Mboshe.
Njoki Moshe.
Mboshe, M-B-O-C-E.
Yes.
I am not representing the 43rd respondent.
Yes.
Mr. Ndegwa is my learned brother, and he has indicated that he's on his way.
So who are you representing?
I am representing the 45th respondent.
45th respondent.
Indeed.
Thank you. 10 minutes.
Oh, my Lord.
Yes, all the grounds have already been argued. So take your 10 minutes. If you need any more time beyond that, we will determine.
Most obliged. Thank you very much. And my ladies, my lords, as I've indicated, my name already, I represent the 45th respondent in this appeal.
Yes.
And my lord, my ladies, we support the appeal. And why is that so? My lord, our main association with the appeal is because the appeal is urging this honorable court to find that nobody can legally oust Wanjiko's right to self-determination. My lords, my ladies, and this is essentially anchored on challenging various provisions or various findings of this honorable court, particularly the findings, and these are set out at page 310 of the supplementary bundle by the Attorney General, particularly, my lords and my ladies, the provision or the finding that the basic structure doctrine does not apply with respect to Article 250, or will apply, sorry, my lords, my ladies, that it applies with respect to Article 255, sorry, Article 256 and Article 257. My lords, my ladies, we submit that the doctrine of basic structure does not find any place within the Constitution of Kenya, Article 255 and 256, and this is because, my lords, my ladies, when my lords and my ladies retire, you will find that the case of Njoya has been referred to, and the Honorable Trial Court indeed looked to it with respect to the issue of the basic structure. My lords, my ladies, that particular case was addressing the aspect of parliamentary initiative, because that is what Section 47 of the then Constitution was looking at. It is not that particular provision of the Constitution or of the previous Constitution, my lord, does not have a provision like we have in Article 257. Therefore, because now we have Article 255 and 257, they anchor the provision that Wanjiku has the sole sovereign responsibility and right to self-determination to determine, my lords and my ladies, which kind of constitution she wants. And we cannot, my lords and my ladies, as we will find at the preamble of the Constitution, Wanjiku has not donated. She has not given up. She has not given up that particular right. She continues to hold it for herself and her future generations. Therefore, she will not want to be bound by eternity provisions or provisions that seek to suggest that no amendments can be done to the Constitution. Wanjiku reserves that right. She is required and she's entitled to keep it, my lords and my ladies. And therefore, the finding on page 230 with respect to that particular argument and declaration 1, that the basic structure is applicable to 55 and 256 and 257, my lord, is erroneous, both in fact and in law. My lords, with respect, and also when you look at the case of Kesavananda, my lords and my ladies, that was applied extensively by the High Court with respect to this matter, my lord will see that that case cannot apply to Kenya. Why, my lords and my ladies? Again, because that particular consideration with respect to the basic structure doctrine was looking at parliamentary initiative, my lords and my ladies. And therefore, because our Constitution distinguishes itself by giving specific powers to, and not even specific powers, it is Wanjiku who has kept it for herself. So she's not being given. She has kept it for herself under 255, 256. Therefore, any application in India or in any other jurisdiction cannot apply to Wanjiku's case. Again, my lords and my ladies, we humbly suggest, persuade this court to find, and we actually submit that the need for abundant caution when adopting foreign laws, including this particular Kesavananda case, has been emphasized time and again, my lords. And I would like to refer this court to the case of, to the finding in Nyali versus AG, one All England Law Report, where, my lords, even the courts in the jurisdictions that we're trying to borrow from are cautioning us. Lord Denning himself is cited there as cautioning us and saying that even that common law that we are borrowing, we should be very hesitant, my lords and my ladies. And in that particular case, even the court there says that this power is really entrusted to these honorable courts to make sure that we are not importing things that will not apply to us. I therefore urge that this court finds that that basic structure doctrine that was anchored in the finding of the High Court on the Kesavananda case, on the Njoya case, and on other academic literature that are not applicable within the Kenyan context, my lord, to actually not apply to Kenya, and therefore the finding with respect to the basic structure doctrine application in Kenya has no anchor in the Kenyan constitution. My lords, my ladies, I'd like to submit, secondly, on the issue of the boundary delimitation. My lords, my ladies, I do associate with the submissions by my senior, Mr. Karori, when he spoke to the issue of Article 89 of the Constitution of Kenya 2010. My lord, that provision is very clear, that the IEBC, and that is sub-Article 2, the IEBC shall review the names and boundaries of constituencies at intervals. So with respect to constituencies, the IEBC can only deal with the issue of names and boundaries with respect to constituencies. But if the Constitution had intended for the issue of the numbers to fall within the mandate of the IEBC, honorable my lords and my ladies, nothing would have been easier than for the Constitution to have said that.
89 talks of constituencies or wards?
It talks of two, and I was getting there, my lord.
Okay.
Sub-Article 3 talks about the wards, and it gives the IEBC that particular mandate with respect to the number of wards, but it doesn't give it the mandate with respect to the numbers of constituencies. Who has that right? Wanjiku. My lords and my ladies, where this is not a random thing, the IEBC actually expressed that particular concern and limitation, and my lords and my ladies will find that, and I should perhaps have started by indicating the documents that we have filed. My lords, my ladies will find that IEBC did make a report in the year 2012 and presented it to Parliament, and that particular report is found in our bundle, which looks like this. It is blue, and we have indicated that we have, if my lord will just give me a minute, in that particular report, and I'll just very shortly give us the page that it is contained in with respect to our bundle. My lords, at page 28 at clause 3, which is the conclusion of that particular report, the IEBC provides or concludes and says, and it's a report, a revised report that is being presented to Parliament, the IEBC says, and I quote,
yes,
the limited, as one of, as some of its, in its deliberations, the National Assembly, so the revised preliminary report presented to the National Assembly in accordance with Article 89, sub-Article 7 of the Constitution and Section 3D of the IEBC Act provides a mechanism for structured consultation, and it says that when Parliament is looking at the various considerations, that it should be guided by the fact that through many presentations and memorandum, Kenyans expressed the need to have more constituencies and wards, but this would not be granted due to the limited numbers of constituencies and county assembly wards. My lords, my ladies, the IEBC in 2012 acknowledged that it was restrained by the Constitution, and that is why it is only Wanjiku who can find or who can adjust her boundaries. And therefore, my lords and my ladies, the finding by this honorable court that in page, with respect to the fact that Wanjiku, or that the provisions within the bill that make proposal on constituencies, my lord, is wrong. It is anchored on errors of facts and law, because that particular ambit, that particular mandate is given or is retained by Wanjiku herself. My lords and my ladies, I would also like to address this honorable court with respect to the issue of the...
How many more minutes, Council, Ms. Moshe, do you require? Because your 10 minutes are done.
Indeed, I would have requested for 50, but I'll just take 15.
No, we'll give you 5 more. 5 strictly.
I am most obliged, my lord. So, my lord, with respect to the president, I would refer us to Article 131E of the Constitution. My lords, my ladies, I'm just not able, constrained to going to my constitution because of the time limitations. And my lords, my ladies will find that the president has a duty, and it is also a function for the president to be a symbol of national unity. And that he has a duty, a mandate, to do everything within his powers to make sure that unity is indeed obtained. My lords and my ladies, when you retire and you'll be looking at the mandate and the basis upon which the building initiative process perhaps was undertaken, you will find that it is anchored on the pursuit of peace. And therefore, my lords, my ladies, our submission is that any act that the president may have undertaken with respect to the building bridges initiative is anchored solidly under Article 131 of the Constitution of Kenya 2010. My lords, my ladies, as I wind up, the issue of public participation. My lords and my ladies will find in our, and please, you will find it in the 45th Respondents Bundle of Documents, my lords. You will find that one of the documents we have attached there in response to the application for additional documents that was made, my lord, is the statement, it's communication by the Speaker on 5th May 2021 and in March as well, 2021, to the House, my lords, my ladies, with respect to the processes that constitutional amendment is required to take. And you will find, actually, the 5 points that have been raised in that affidavit that was submitted, the additional affidavit that the court gave leave for, have been addressed concretely in that particular communication by the Speaker, my lords and my ladies. Then to the issue of the public participation as well with respect to the county assemblies, it is a humble submission, as my lords, my ladies will find when you retire, that public participation is solidly, with respect, my lord, to the process and how it's supposed to be conducted. And this particular process of popular initiative is anchored within Article 257 of the Constitution. Therefore, my lords and my ladies, the finding by this by the High Court with respect to introducing other parameters of how this particular process under 251 and 255 should be conducted are extraneous factors, my lords and my ladies, that again are nowhere within the Constitution. If Wanjiku had intended, nothing would have been easier than for her to have included those particular provisions. I associate myself fully with the submissions by the Attorney General, with the submission by the BBI, and with the submission by the President, as well as the submission by the Right Honorable Raila Odinga. And my lord, I urge this honorable court to find that those particular references with respect to the basic structure, those particular references with respect to the basic structure cannot apply in Kenya. Wanjiku, when we say that eternity provisions, and my lord, I did hear one of my lords ask the question with respect to the interpretation of the eternity provisions and looking at it from the artistic side. But my lord, I urge you to find that that was not really the intention of the court when it says that those particular, nothing can be changed. They actually say that in one of, if I could find it, it is in that the basic structure limits, I had highlighted it, but I haven't been able, but when my lord retire and my ladies retire, you will find that the court expressly says that that basic structure applies with respect to 255, 256, 257. It is erroneous, my lords. Wanjiku has the right, and Wanjiku should therefore be protected. Well, in the interest of time, I will also say with respect to public participation, my lords and my ladies, everybody in this country was invited to participate, including, my lords and my ladies, the judiciary. And actually, even the judiciary did give There was a statement of the former Chief Justice dated 26 March 2020 on the views submitted to the BBI regarding the JSC and the judiciary.
Yeah, we agree, that is true. We also participated.
Indeed, thank you so much, my lord. And you will therefore agree.
To that extent, even when we are giving directions, we say that
Yes.
The Chief Justice asked even some of the judges to make their views with regard to the issue of ombudsperson. So thank you very much, Council, for representing the County Assembly of Murang'a.
Of
Thank you.
Kiambu.
Oh, Kiambu.
Indeed, but I do like Murang'a, my lord.
No. Council, can you clarify, because the 45th respondent, according to our record,
Is Kiambu County. That is in 291, and then in 292.
Oh, sorry. In 290, it is, yeah, the other one is 45. So this is the County Assembly of Kiambu.
Indeed, my lord.
Thank you very
much. And then
much.
in 292, you'll find that we are 48.
Thank you very much.
We urge this court to allow the appeal.
Thank you very much. For record purposes, is there any other respondent who is supporting the... This is Mr. Wu. We call...
Can you find out what happened to the standby generator? Because we are not supposed to be having You will excuse us because I think we have been told that there's a problem with the generator. It's supposed to come on automatically. Now, Mr. Is it
Professor Miguel,
Oh, this is Professor Miguel. I can't see you properly, yes.
I may take off my mask.
No, what we propose to do, because it is 15 minutes to the time we have adjourned anyway, we want to adjourn now, and this will be done here because of lack of power.
My lord, before you adjourn,
Yes.
if you may, I'm just seeking direction. I'm appearing as amicus, neither supporting the applicants nor the respondents, but I'm at the disposal of...
Amicus will require that we simply file your submissions.
Very well.
That is what we need.
Much obliged.
Thank you. So, with that, council and parties, the court will adjourn until tomorrow.